I'm so excited to introduce Wendy Kaminer. She is a lawyer, a social critic, and a civil libertarian feminist. She writes about a lot of interesting topics, and she has written a ton of incredible books that I love, and I'm so excited to have her here today to speak to you. And at the end, we will have question and answers for this, a Q&A session, so please write down if you have anything to talk to Wendy about, and yeah, I welcome you here, Wendy.
Thank you. Thank you all, and good afternoon. I won't apologize for not being Marcy Hamilton, because I've always been happy enough to be myself, but I am sorry that she's not here. I would have liked hearing from her as well, and I'm sorry for those of you who are looking forward to hearing from her too. I do apologize for my voice. It won't go out on me, but you'll just have to bear with the hoarseness. Now, I'm here to offer a contrary view of the conflicts between religious community and the rights and interests of their members. In fact, I don't generally view these conflicts as collisions between religions and rights, as the title of the conference implies. I view them in a couple of ways. One, as collisions between religious liberty and state power, and also as collisions between religious liberty and civil rights, between the essential freedom to form your own religious community according to your own beliefs, and the rights of the community's members, especially minors, who are members through no choice of their own. And I can't categorically choose sides in these disputes. I can only weigh the claims of each side in any particular case or controversy. I may well have a more sympathetic view of religious liberty claims in many of these controversies than many of you do, and I'm not here to try to change anyone's mind. I do hope to offer you a perspective that you'll find worth considering. And I know that many of you come to this subject with personal experiences of religious oppression, which I have been fortunate enough to be spared. I've been shaped by a very different set of experiences, convictions, and concerns about governmental intrusions on liberty. After all, when you seek to liberate people, especially minors, from the control of religious communities, you're seeking governmental intervention, whether in the form of laws requiring Amish parents to send their kids to school beyond the 8th grade, or laws prohibiting Mormons from engaging in polygamy. I'm going to focus on controversies involving minor children because, in general, I think the plight of adults who feel trapped or oppressed by religious communities requires self-help, the aid of private advocacy groups, not state action, unless, of course, there's evidence of criminal conduct. So let me start with the easiest case for government intervention, the religious-based refusal of parents to provide their children with essential medical care. These are the easiest cases because the harms that are inflicted on kids are so apparent and easily quantifiable. They're objective. I'd like to use these cases to explore the pitfalls of state intervention, precisely because they are the cases in which intervention is the easiest to defend. Take the 1990 Massachusetts case, Commonwealth v. Twitchell, which involved the involuntary manslaughter conviction of a Christian Science couple who failed to provide their 2-year-old son with medical care that could conceivably have saved his life. They retained a Christian Science healer instead and prayed over the boy unsuccessfully. The Twitchells were sentenced to 10 years probation, no jail time, and they were required to provide medical care for their surviving children. Now, the conviction was overturned on appeal for errors at trial, but the appellate court upheld the basic theory of the prosecution, that parents could be guilty of manslaughter for failing to provide medical care for their children for religious reasons. But putting any of the due process violations aside, I think the prosecution of this case was entirely appropriate. I think the sentence was fair. I'm not going to defend religious exemption laws for medical neglect, including exemptions for vaccinations. But again, I do want to consider the potential downside of medical neglect prosecutions involving religious belief. They're easy to defend when you characterize the cases as cases about children's rights. But Commonwealth versus Twitchell, for example, can also be accurately described as a case that pits the rights of parents against the power of the state to make decisions about a minor's health and welfare. Now, in this case, I imagine we agree that in a life-death situation, the state was acting in the best interests of children, and the parents were not, unless perhaps you think the child's salvation was at stake. But this is just one case. Take an extreme example of harm inflicted by the state against the interests of children, using the excuse of saving the children from their parents, and that's the Trump administration child separation policy. According to the ACLU, and this is a quote, "The government is systematically separating large numbers of families based on minor criminal history, highly dubious allegations of unfitness, and errors in identifying bona fide child-parent relationships." Now, of course, we can evaluate, and we expect courts to evaluate, the harm to children inflicted by parents who deny them medical care and the harm inflicted by the state child separation regime. These controversies are easily distinguished, and I'm not suggesting that there is some slippery slope from the Christian Scientist cases to the Trump administration's cruel crusades against refugees. But I am pointing out that the government is not necessarily more trustworthy or better qualified to protect children than their parents, whether or not they're driven by religious beliefs. Now again, the administration's child separation policies are easy to distinguish from good faith efforts to separate children and easy to condemn. But consider harder examples involving child separation and state power and state usurpation of parental rights, the historic and ongoing controversies over the enforcement of child neglect and abuse laws by government welfare agencies. A recent article in the New Republic highlights, quote, "the crime of parenting while poor as construed by New York City's Administration for Children's Services." And this is a quote, "Many issues that fall under the broad umbrella of neglect, which alone accounts for 73% of all allegations of child mistreatment made to ACS, are simply the everyday struggles of low-income families." End quote. A report from WNYC on the abuse of emergency child removal powers notes that in 2018, of the 3,633 children removed from their parents, the city used emergency powers nearly half the time. Almost all of the children involved in these removals were non-white, reflecting a system that by and large only surveils Black and brown families. Am I digressing from a discussion of interfamilial religious abuse? I don't think so. Not if you view the religion cases as conflicts between state power and parental rights, whether they involve the beliefs of Amish or Christian Science parents or other sects. Indeed, when parents are acting on religious beliefs, their arguments for autonomy from the state are particularly strong, given the constitutional issues involved, but also the political values we do or should place on freedom of conscience. The state, after all, is as likely to abuse power as any number of closed religious communities. It is especially prone to discriminate, not just against low-income Black or brown families, but against unpopular or outre religious groups. Take the 2008 case involving Yearning for Zion, which was a polygamous sect inhabiting a compound in Texas. On the basis of an anonymous phone call, which turned out to be a hoax, the state raided the compound and forcibly removed over 400 children from their parents. 2 weeks later, a state court judge refused to release the children from the state, ordering all parents and children to undergo mandatory DNA testing, which seemed to be an ex post facto attempt to justify the illegal raid and seizure of children. It was also reported after the fact that some 20 minor females in the compound had been impregnated. But as the state eventually conceded, teenage pregnancy by itself is not a basis for removing children from their home. And state officials had also seized toddlers and school-age children who were not even alleged to have been at risk from abuse. Now, I'm not romanticizing this compound, which was led by the notorious Warren Jeffs, now serving a life sentence for the sexual abuse of minors. But he was not abusing, and was not even alleged to be abusing, the over 400 children who were separated from their parents. Hundreds of children were consigned to foster care without any due process or any particularized showing that their parents were endangering them. 2 months after the raid, a state appeals court ordered the children released to their parents, recognizing that they had been seized without any evidence of endangerment. Now, why do I consider this discriminatory? Partly because it's hard to imagine the state conducting a comparable raid on a religious community considered respectable. The state does not, for example, summarily cease all Christian Science children in a given community after receiving reports that a child had been denied medical care, nor should it. Why should we care about the religious liberties of people involved in insular religious communities that isolate children and fail utterly to prepare them for a life outside the sect? One former county commissioner interviewed by a Texas paper didn't care, declaring, quote, "The abuses that occurred within the polygamous community outweigh any arguments about religious liberty or criticism of the state's abrupt removal of children." Now, some of you might agree with that, and I might agree with that if the evidence of abuse had been there before the raid. But again, the state separated children from their parents without evidence of abuses. It acted on the basis of assumptions and animus towards polygamists. The local community was reportedly shocked by news that the polygamists were coming to town. According to one report, as stunned townspeople gathered outside the courthouse to hear the news, one woman held up a sign that said, "The devil is here." Now, whether or not you believe in Satan, it's hard to conjure up much sympathy for an insular polygamous sect under the leadership of a convicted rapist, but it should go without saying that we should not have to sympathize with any group, religious or otherwise, in order to respect and advocate for its civil liberties. Religious liberty doesn't include the freedom to abuse children, of course, but it does bar the state from forcibly acting in loco parentis on the basis of biases or hunches, even if after the fact the hunches turn out to be partly right. It's a little like arresting and convicting people and then presenting the evidence. State action requires evidence of abuse before, not after the fact. The rule of law is only a rule if it's applied indiscriminately. Discrimination also factored into another medical neglect prosecution from the late 90s, another Massachusetts case, involving a small Christian fundamentalist sect called the Body. According to a diary turned over to authorities by a sect member, children in the sect were dying, including the infant son of Rebecca and David Corneau. He allegedly died shortly after birth because he was denied medical care. The Corneaus claimed that he had been stillborn. Based on these allegations, the Commonwealth took all of the children in the sect, including the Corneau's daughter. Subsequently, in the alleged interest of a fetus, the government incarcerated the pregnant Rebecca Corneau, forcing her to give birth in custody. A judge upheld her incarceration, claiming the fetus spoke to him and said, quote, "I want to live, I do not want to die, I do not want to die like my brother Jeremiah did." Now, let's assume he was speaking metaphorically. That's my assumption. The government still took actual custody of the newborn that Rebecca Corneau bore in custody. The case raised obvious concerns about female autonomy, the power to force a woman deemed to be a bad potential mother to give birth in custody and hand over her child. It's not that different from the practice of incarcerating pregnant women with histories of drug abuse and forcing them to give birth in custody. This saga continued, and concerns intensified soon after when Rebecca Corneau was reported to have given birth to another child. The Corneaus claimed she had miscarried. The judge imprisoned both husband and wife for contempt, claiming he could not confirm their claim. Now, this is a bizarre case that may pose extreme examples of child endangerment. You would not want to turn your child over to this sect. But consider the power exercised by the government in its battle with the Cornots over the well-being of their children. State officials didn't simply seize the children. They effectively turned Rebecca Cornot's pregnancies into crimes, incarcerating her during one pregnancy and then again for another, which she claimed had ended in a miscarriage. The government is not a trustworthy ally. Why do I consider this case another example of discrimination? Because I believe the government's excessively harsh treatment of Rebecca Cornot reflected her membership in a small religious sect easily characterized as a cult. Now, I define cults as completely insular or totalitarian communities that completely cut off their members from the outside world, and maybe the Cornot sect would have qualified. But cult is, of course, quite a pejorative term. People often just apply it to religious sects that are outside the mainstream or that they don't like very much, or that are considered weird. Christian Science is not generally considered a cult, partly because it's a mainstream indigenous American religion. And if Cornot had been a Christian Scientist credibly accused of fatally denying a child medical care, I doubt very much that she would have been in prison subsequently for the crime of becoming pregnant. Again, give the state power to assume the role of parent to allegedly neglected children, and you can bet that that power will sometimes be abused. The abuses will not only affect the parents, families, and communities at issue in any particular case. They potentially affect us all. The treatment of Rebecca Cornot was a power grab by the government that established a dangerous precedent and posed obvious threats to reproductive freedom generally. Everyone's rights and liberties matter. When the state decides that those of one group matter more than those of another, then everyone's rights and liberties are at risk. Atheists who are denigrated about as much as polygamists should surely understand this. Religious freedom is simply a subset of freedom of conscience, and freedom of conscience belongs to us all. Now, sometimes claims for religious rights and freedoms really are demands for religious power. I think that's most obvious in debates about school prayer. When you demand or simply encourage that public school students recite an official prayer, that's an affront to religious freedom, not an accommodation of it. That is also an easy case. Now, what I consider hard cases, and I think I might be in a minority of one on this, are recent battles over the arguable freedoms of religious small business owners, bakers, florists, photographers, who want to deny services to same-sex weddings. Now, these cases are not exactly on point to our discussion here. They don't involve parents or communities. That arguably limits the rights and opportunities of their members. But they are useful examples of the tension between individual freedom of conscience and civil society's values and laws. The same tension that underlies cases involving state power to intervene in the raising of children. So I want to spend just a couple of minutes on these controversies. I could, and I think I have, argued both sides of them. Allowing commercial enterprises, no matter how small, to discriminate against customers on the basis of religious belief is an obvious threat to the ideals and the efficacies of our civil rights regime, which I support. If individual business owners can refuse to service same-sex weddings, they could conceivably refuse to service interracial or interreligious weddings or other events that are contrary to their religious beliefs. Yet, I still think the business owners are raising legitimate freedom of conscience claims. And in my view, any religious exemptions extended to them could be limited in ways that greatly minimize the threat to equality and civil rights. If, for example, we had a First Amendment exemption for mom and pop businesses with fewer than, say, 8 or 10 employees who are not engaged in providing essential services. In these cases, I think the harm of denying freedom of conscience claims outweighs the harm of accommodating them. And I'm actually drawing this example from the 1964 Civil Rights Act, which exempted small businesses, I think of 15 or fewer employees, from the rules against employment discrimination. It also exempted owners of like bed and breakfast, small owner-occupied bed and breakfast with maybe fewer than 5 or 6 rooms from the new rules about housing accommodation. That's not following a principle all the way to its end, but it's offering what I think is a livable political accommodation or compromise. And sometimes that's important, and sometimes that gets you further along the road to where you want to go than being really absolute about your principle. But that's a political debate, maybe for another day. Anyway, in these cases involving the bakers and the florists and the photographers who have religious and speech claims, I'm obviously making a value judgment when I weigh the conflicting claims, and that's what we all do, and we're all going to come out somewhat differently. It's what courts do in deciding these cases, and it's what they do in deciding cases between parents and the state over the right to raise children. Now, by positing cases about religiously motivated medical neglect as conflicts between state power and religious liberties and parental liberties, I don't mean to be dismissing concerns about children's rights. They're very clearly at issue. I'm just trying to give you another framework for viewing the cases. Although when very young children are involved, the cases really center on deciding who controls their fates, parents or the states. That's what those cases always come down to. Older children, especially those close to the age of majority, should have a say in determining their own fate, and that is one of the lessons, I think, of Yoder v. Wisconsin, which is the case exempting the Amish from the obligation to enroll their children in school beyond the 8th grade. The court should have paid much more attention to children's rights. Yoder is an odd and, in many ways, a very anachronistic decision with its romanticized view of pre-modern life in an Amish community isolated from the secular world. And the children involved were old enough to state their own educational preferences, as Justice Douglas observed in his dissent. On the facts, I don't think this was a particularly hard case. What's interesting about Yoder to me is its status as a homeschooling case. There are a great many non-Amish homeschooled kids being denied the equivalent of a high school education. Estimates that I've seen range from 1.5 to 2 million. Generally, homeschooling is regulated by the states quite erratically, and the regulations that do exist aren't necessarily consistent or consistently enforced. Homeschooling has its share of advocates motivated by religious belief and religious objections to public school curricula, but it doesn't primarily involve a clash between claims of religious freedom and state power. It reflects the strength of ideas about familial autonomy and the freedom of parents to raise their own children according to their own ideals. Given the ways in which government power is used for both better and worse, those ideals are both a blessing and a curse. Thank you. Now, I think we have some time. I'm happy to take questions, comments, accusations, arguments. The only thing I will ask for you is that you not go on too long in case other people have questions, comments, accusations, and arguments that they'd like to raise. Yeah.
What is your position on New York State finally stepping up to the plate and trying to enforce substantial equivalency requirements to children who are not attending public school? And it is now particularly a heightened moment.
To homeschooling kids.
Well, not only homeschooling, but, from my perspective, an involvement with the issue of children, particularly the boys, attending Hasidic yeshivas, many of which are not being provided a secular education.
Yeah, I think that's a really hard question. I think it's an easy question if it comes to kids who are being homeschooled on the basis of no religious belief. Or even, I would like to see stricter regulations and some kind of equivalency regulations for homeschooling generally. problem is, if kids really are being homeschooled, enforcement is very difficult. I'm hesitating a little because I'm not an expert on this, and I always hesitate to give a firm opinion about subjects that I really don't know quite enough about in detail. So I'm just going to try to talk generally about the principle. And now that in religious schools, I think it's a very hard call because of the religious liberty claims. I do. No, I understand. And I have a lot of sympathy for the kids who are stuck in these schools and not getting a decent or equivalent education. I'm just saying I don't consider it an easy case because of the religious liberty claims involved. Now, again, the children are older, and it seems to me if there are court cases about this, and if there are fact-finding, I don't know if this makes any sense in terms of, I'm assuming these cases are going to be argued on federal constitutional First Amendment grounds by the schools. That would be my instinct, right? Is that what's going on? I'm not familiar with the... Has not enforced. I would guess that if they were going to be enforced, that the defense of the schools would be a federal constitutional defense. Maybe. It seems to me that the children, especially if we're talking about high school, junior high school, and high school age kids, that they ought to have a voice in any litigation because they're old enough. I know I'm not giving a very satisfactory answer to this, but I find it a hard case and I haven't given it a lot of thought, so I don't want to give a definite answer. Actually, I don't. I consider that as a matter of policy. I do not consider that as a matter of constitutional right. I consider the claim, the individual rights of the students on the one hand, and the individual rights of the parents and the religious community on the other, but I do not consider that the community at large has any constitutional rights at issue in this. They have policy concerns, but not any constitutional rights from my perspective. Well, financing is different. I'm not in favor of any public financing for any religious schools, whether it's in the form of vouchers or anything else. Financing religious schools with public funds to me is a clear violation of the Establishment Clause, but I'm not on the Supreme Court. Can somebody ask me an easy question?
Well, I don't know if I can do that, but so you distinguished a bit between discrimination in employment in the accommodation or the exemption that's in the Civil Rights Act for businesses that have fewer than 15 employees. The distinguishing question that I have there is about customers, that we're talking about. There's a difference, I think, between discriminating against customers for a public accommodation versus discriminating against employees if you're a small business. And so I'm just wondering if you think that it would be appropriate to, for example, amend the Civil Rights Act to include a similar accommodation for, as you put it, mom and pop shops that are providing non-essential services to discriminate on the basis of currently protected classes, and just your thoughts on that in weighting liberty claims in terms of free association and whatnot.
If one of these bakers or florists or photographers said that it's against my religious beliefs to service, I don't know, African Americans
yes.
or Jews or
and if there's a distinguishing
Asian people,
if there's a distinguishing thing between LGBT folks and African Americans or Jews or anything else,
I don't think there's a principled legal distinction. I think there is a pragmatic political distinction. And I'm not presenting my proposed compromise as entirely principled from a legal perspective. I'm presenting it as a matter of comedy, because I think if we're dealing with non-essential, now I know when I say a wedding cake is a non-essential service that people who are in the middle of planning their weddings, might be in an uproar over that. But I think it's a non-essential service. I'm willing to call it that. I think as a matter of comedy, when we're dealing with these mom and pop operations that are providing non-essential services, and there is still a lot of controversy and resistance over gay marriage, especially among religious communities, that I think we need some tolerance on both sides. I think the market is going to take care of this because we've made enormous progress in gay rights over the last 20 years. I mean, I'm older than a lot of the people here, and the progress has just really been astonishing. It's just astonishing. And I think we're going to continue moving in that direction. And I think in many ways that if we were to just, I don't want a court ruling that says these people have a right to discriminate. I don't want the cases brought to begin with, because I think they can make bad law. I think they can aggravate a lot of resistance to LGBT rights and dress them up as concern about First Amendment rights, which they sometimes are and they sometimes are not. So I'm really presenting this as more as a pragmatic political compromise, which in my view is going to get us further along to the goal of equality than bringing these cases and raising these controversies. But I know that I'm in a small minority on this. Does that make sense to you?
I disagree. I understand.
Okay.
I'd like to ask about the data laws.
About what laws?
Data privacy.
Oh, privacy.
With regard to, for example, blood transfusions and Jehovah's Witnesses. It's been the practice of Jehovah's Witnesses congregations to promulgate medical care proxy cards and specify that the card carrier will not accept blood. But in addition, those end-of-life decision forms or medical proxy cards have been logged by the congregations. Somewhat in violation of the HIPAA laws. But recently, the European Union enacted a much broader set of data privacy laws which made it illegal for congregations or other business entities to track personal data without permission. So that with the broader enforcement in the EU for data privacy, the congregations have been forced to turn back or devolve or divest themselves of that tracking function. So I'm interested in your legal view as to whether in the United States we should have tighter, more enforceable data privacy as a protection for people seeking freedom of choice or religious freedom that includes both sides.
This group asked a lot of hard questions.
No, that was an easy shift.
It's easy if you're an expert in privacy laws. If your general question is, do we need more privacy laws and data protection, I think that's an easy question, absolutely. Let me ask you something. Why do the religious communities need to keep track of the individuals?
Spiritual care. Meaning, if you need blood transfusion, we'll be at the hospital to make sure that you don't ask for it.
Well, can't people carry their own, don't people carry their own cards with them, or can't they do that?
Yes, they do, but that would be useful in an accident situation where EMT would have the right to transfuse on the spot without asking a question. For example, if the accident victim were unconscious, it is not the obligation of the person responsible to even look.
Well, but what are the chances that a member of the community is going to be with the person who gets involved in some accident and is unconscious when discovered by the EMTs? I'm just trying to understand the premise of your question and the reason why the communities need to keep these records.
Was whether
Because if the communities don't really need to...
privacy is a solution, and we seem to see that working in the EU with their new data privacy law.
I'm sorry, I was talking over you. Say that again.
To bring data privacy into the discussion of religious freedom. And whether you've already answered that yes, we need better protection for personal data privacy. But in the case of a blood transfusion,
I think if people within a religious community choose to share personal information with the community, that should be their choice. I don't think the state should tell them that they are not allowed to make the choice of sharing their personal information with their religious community.
so in the case
Does
in
that answer your question?
The case in question, the Jehovah's Witnesses are saying if you want anything to do with us on an official basis, with some appointment or some position,
Well, people can make that choice.
then you have to give us the complete.
But that's the choice of the individual. I mean, and if they feel more strongly about being a Jehovah's Witness and being an official member of a community than about safeguarding their data, that's their choice. If they feel more strongly about their data than being an official member of the community, that's their choice. That's not our choice as a public to make for them.
So in a sense, then you're saying data privacy is a good thing, but we're not going to enforce.
No, I'm not
As they
saying
are in
that.
the
I'm
EU.
saying that ideally, we would each have the right to determine what data about ourselves we want to share and what we don't want to share. And the problem that we're facing now, apart from any discussion of religious communities, is that we have no choice. All our data is just being shared not just without our permission, but even without our knowledge. And I think what most people want is control and the ability to make their own decision about what's shared, with whom it's shared, and what's not shared. And, ideally, and I don't know if this will ever be possible, but if I were designing the world, I would design a world in which how much you share and don't share and who you share it with is entirely up to the individual.
Which was
If anybody has questions, please put your hands up.
Anybody else?
Going back to the cases you mentioned where the government removed children from the custody of their parents, in your opinion, what should the government do in the event that they receive an anonymous tip like that, alleging that there is abuse or violent crimes against children in a compound or a religious insular community or something, but they have no other corroborating evidence yet?
They should investigate it, which they did not do in this case. They acted on an anonymous tip, which turned out to be a hoax. They should investigate it. Corroborating evidence, that is a controversial term in a lot of ways. The evidence doesn't have to show beyond a reasonable doubt that there's abuse going on, but they have to have some evidence that gives them probable cause. It's like the kind of evidence that you need for a warrant, that gives them something like probable cause to go in and seize children, at least temporarily, and then have a very short window in which to go before a court and make their case, and have the parents go before the court and make their case. But, I really don't think we want law enforcement people acting on anonymous tips. That would put us all in a lot of trouble.
We're out of time.
Are we out of time? Thank you all.